Mr. Gates is entering a plea of guilty to the charges of voluntary manslaughter and armed robbery pursuant to North Carolina v. Alford. Katarina Wright was killed in her Columbus apartment on November 30th, 1976. Approximately $480 in cash was taken from the apartment. If the case were to go to a retrial, the state would seek to present a signed written statement and a videotaped statement in which Mr. Gates stated that he committed the charged crimes. The state would seek to present evidence that Mr. Gates' fingerprint was found at the crime scene approximately 2 months after the offense. The state would seek to present evidence that Donald Hudgens, who lived in the same apartment complex as the decedent, picked Mr. Gates out of a lineup and said that Mr. Gates came to his door on the day of the crime purporting to be from the gas company. Mr. Gates would seek to present evidence that in 2017, DNA testing was conducted on the belt and tie used by the perpetrator to bind the victim. A DNA expert found that Mr. Gates' DNA is not present on the belt and tie. Mr. Gates would seek to present evidence that type B blood was found on the door next to the decedent's body, and both Mr. Gates and the decedent had type O blood. Mr. Gates would seek to undermine the state's evidence, including on the bases explained in the Georgia Supreme Court's decision dated March 13th, 2020, which is hereby incorporated by reference. Mr. Gates maintains that he is innocent of the charged crimes. However, in light of the foregoing, Mr. Gates recognizes that it is in his best interest to accept the proposed plea agreement pursuant to Alford. As stated previously, the proposed plea agreement is that Mr. Gates will be sentenced to 20 years for voluntary manslaughter and 20 years for armed robbery. The 20-year sentence for armed robbery will run consecutive to the 20-year sentence for voluntary manslaughter. Mr. Gates will receive credit for time served. The intent of the parties is that this plea agreement will resolve this case and Mr. Gates will be released from custody immediately. Therefore, Your Honor, the Office of the District Attorney and Mr. Gates respectfully request that the court accept Mr. Gates' plea of guilty to the charges pursuant to Alford.
The Alford plea just gives the opportunity for somebody to say, I didn't commit the crime, but I know there's enough facts and there's enough evidence that a jury may be swayed to convict me. So I'd rather than roll the dice and take a chance, I will settle for this plea bargain agreement. This was a question. Will he have to be returned to the prison system and be released, or can he be released, or has that already been taken care of?
That's already been taken care of, Your Honor. We've been in contact with both the jail and offender administration, and Mr. Gates will be released from the jail.
Okay, so that's in the record, and just want to make sure that's clarified. And sir, how do you plead to the charge of voluntary manslaughter?
The guilty to the Alford plea.
All right, sir. It's actually a plea of guilty. And you say guilty?
He said the same plea, sir.
He's wearing that mask and I really can't understand him. He say guilty?
Yes, Your Honor. He said the same plea, guilty to the charges pursuant to Alford.
All right, which is his right to do. All right, the sentence on the court, based on y'all's plea bargaining agreement, which I will follow, is that he will serve 20 years on the voluntary manslaughter, which is the maximum sentence, and 20 years on the armed robbery. Those will run consecutively, as my understanding y'all worked out, and that will be concurrent with the sentence that he's already under. Is that correct? Is that y'all's agreement?
That's correct, Your Honor.
All right. You have a limited appeal, sir, after today. Your lawyers can go over that with you. You are a convicted felon. You cannot have any weapons, firearms. And unless there's any other questions, that will end the session today.